Ms. Henderson.
Before the short adjournment, I was dealing with the unconditional and conditional parts of the contract. Of course, one consequence of the unconditional parts of the contract coming into effect immediately in April 2015 was that the governance issues which were affecting the company could be hived off, and the company or the charity could operate as it did perfectly well, free from those troubles, or substantially free from them, as illustrated in the 21st of June 2016 letter, which both my friend Mr. Morpus and Mr. Crowe took you to. It's the letter tucked in at the end of Mr. Crowe's written case.
That must presumably have been apparent to the judge, to the Chancellor.
Yes.
Yes. Although it hadn't happened, because as I understand it, the resignation only takes effect when the final determination is made.
The
but it was
resignation
going
only
to
takes
happen.
effect from the decision, but the recusal takes effect immediately.
Yeah.
So, as from April 15, Ms. Cooper had recused herself in respect of everything other than issues concerning the payment of the grant. The fact that the charity is running perfectly well under its existing constitution goes to my Lord Wilson's point to some extent about the possible removal of Dr. Lehtimaki under the power contained in the Constitution, because it would be one thing to try to remove somebody if they were causing a problem for the running of the charity, but certainly in terms of its general operations, Dr. Lehtimaki's presence is not causing a problem, and to try and remove him, potentially against his will, would be a recipe perhaps for yet more litigation. The other point I would make, again I'm getting to the end with my miscellaneous points rather than the fiduciary power point, is that the court and the Charity Commission have no power to remove a member from a company apart from under Lady Arden's suggestion, perhaps under section 994 of the Companies Act, unless the member's involvement in the administration of the charity is so great that he or she themselves becomes a charity trustee, effectively grows to get all the powers, or most of the powers, of the director. The charity trustees within the definition in section 177 of the Charities Act, in this case, are the directors of the company, not the members. And there's no statutory power in the Charity Commission to remove members. Then, turning now to the fiduciary duties point, it's the one point which CIF has departed from neutrality upon, and that's because one of its main desires, as this litigation has progressed, has been and remains to obtain as much clarity as possible in relation to the arrangements in respect of the grant and CIF's future conduct. We've already heard today as to some of the difficulties which the use of the word fiduciary and the lack of definition as to what's meant by it cause and can cause. And there's a series of questions set out in our written case, which I won't go through at length, take too long. But they're all questions which arise as soon as you start trying to extend the duty of a member beyond that of a member of an ordinary company, or perhaps beyond what might be called the proper purposes rule. To try and define all the circumstances in which some sort of fiduciary gloss applies, somewhere lying between the proper purposes rule and the full fiduciary obligations mentioned by Lord Walker in various places, including in Pitt and Holt at paragraph 10, would be the work of months, if not years. And it would not be satisfactory for charities generally, and indeed for this charity in particular, for that uncertainty to continue. I think.
But it would be equally unsatisfactory, wouldn't it, for an attempt to set out some kind of template if it wasn't necessitated by the decision that had to be made on the appeal?
Indeed it would, but the mischief, as we see it, with the Court of Appeals and the Chancellor's decisions in this regard, were that they left open the door, at the very least, for there being additional duties, but said they weren't going to say what they were. So that has left the whole third sector, as it's sometimes called, the whole charitable sector, in doubt as to what those duties are, we've heard from Mr. Crowe this morning, and indeed from Mr. Morpus, as what some of the difficulties are. Can Dr. Lehtimaki be reimbursed from the charity for the money he spends in getting a report before he makes his decision? All those sort of questions arise. And it's not just this charity in relation to which they will arise. My own friend, Mr. Pearce, in his case, in a footnote, I think it's footnote number 11, says that the Charity Commission records that as at some date, I think in December 2019, there were 33,000 odd, 33,000 charities charities which operated as companies limited by guarantee. Now, they won't all have to have AGMs every year anymore because the company's law has been changed in that regard and they can opt out. But some of them will, and they're likely at least to have general meetings of their members for one reason or another. Even if they only have to have meetings every other year, that's 33,000 companies, which are charities, 365 days in a year. Divide the one into the other, divide by 2, because you say, well, they're only going to have them every other year. That's still something of the order of 40 or 45 meetings on average per day, where the members of corporate charities are going to have to vote and will need to know whether they are voting as full fiduciaries or as people only subject to the proper purposes rule or as something in between. There's one case I would like to take your lordships and my lady to, which deals with the duties of members in somewhat more detail than has been dealt with so far, and that's the case of Re-Charterhouse Capital Limited. I'm afraid there's a mistake in my written case. I said the relevant judgment was that of Lord Justice Lewison. In fact, I think it was the then Chancellor, Sir Terence Etherton, who gave the relevant judgment. The reference is Authorities Bundle 5, tab 84, at MS 2327, and the relevant passage is at MS 2347. The facts don't really matter. This is a case which was actually referred to by the Court of Appeal in the present case with approval, and it's paragraph 90. It is common ground that an alteration to a company's articles, even if passed by the requisite majority of shareholders, may be challenged as invalid in certain circumstances. We were taken to a number of cases which consider the conditions for an effective challenge. They included Allen and Goldrees, which has already been referred to, and various others. And then says the then Chancellor, I would extract from them the following principles. 1, the limitations on the exercise of the power to amend a company's articles arise because, as in the case of all powers, the manner of their exercise is constrained by the purpose of the power, because the framers of the power of a majority to bind a minority will not, in the absence of clear words, have intended the power to be completely without limitation. These principles may be characterized as principles of law and equity or as implied terms. A power to amend will be validly exercised if it's exercised in good faith in the interests of the company. It is for the shareholders and not the court to say whether an alteration of the articles is for the benefit of the company, but it will not be for the benefit of the company if no reasonable person would consider it to be such. The view of the shareholders, acting in good faith, that a proposed alteration of the articles is for the benefit of the company, and which cannot be said to be a view which no reasonable person could hold, is not impugned by the fact that one or more of the shareholders was actually acting under some mistake of fact or lack of knowledge or understanding, in reference to Peter's American delicacy. In other words, the court will not investigate the quality of the subjective views of such shareholders. And to the extent that I think my learned friend Mr. Morpus agreed with Lady Arden earlier today that the court could look objectively at the decision of a shareholder, I would respectfully disagree. On this authority, it's the shareholder's subjective view which is relevant. The court can only look at it objectively for the purposes of deciding whether or not, effectively, no reasonable shareholder could come to the conclusion that the shareholder came to. But the court will not investigate the subjective views of the shareholder. Similarly, with members of companies limited by guarantee, and indeed I would respectfully suggest the members of many membership organisations. This charity only has 3 members, but conceive of a charity, maybe a local association dealing with community work with maybe 50 or 100 members. Is it seriously suggested that all those members owe any duty to consider with any great degree of care how they vote at any AGM, how they vote indeed if a Section 217 point was put in front of them? They turn up to the AGM if you're lucky. If you're lucky, you get a quorum. They may have a drink before they go in, and they'll then vote as they see fit. They are not going to go through anything like the rigmarole that Lord Walker suggests a full fiduciary needs to go through. And for the point of view of certainty, simply leaving, in my submission, leaving the law as it is, with the members being obliged to comply with what may be called the proper purposes rule, or the rule applicable to members of companies, is all that is needed. There's no need to go further. I endorse what has been said by my learned friends Mr. Morpus and Mr. Crowe about the Attorney General's wide-ranging submission about the court having an effectively unlimited jurisdiction to direct members or trustees or directors how to vote or what to do in circumstances where they haven't acted in any way wrongfully and are not threatening to do so. But if, contrary to that, the court is attracted to that view and decides in that sense, on behalf of SIF, so as to minimise the degree of uncertainty, we would encourage the court to consider that such an intervention should be extremely rare, because the existing case is itself very unusual, and because it's one of those, indeed, rare cases where the trustees or directors have surrendered their discretion to the court, and the court has accepted that surrender, so that the direction of the members how to vote is necessary to give effect to the decision of the court. The Attorney General's submission that the scope of the obligation should be developed incrementally with reference to particular charities or types of charities and particular obligations, really, in my submission, should not be adopted for the reasons I've already given. I won't repeat myself on that. I agree and adopt the submissions of Mr. Crowe about there being a fundamental distinction between, on the one hand, jurisdictions and powers to alter the constitutional framework of a charity, or to deal with assets or income which the existing constitution doesn't deal with adequately, and on the other hand, the jurisdictions and powers to interfere with the exercise of discretions by the persons in whom they are vested under the relevant constitutional framework. So there's a distinction between the scheme and interfering with the discretions of trustees, directors, or possibly members. The distinction between removing trustees and directing them how to act. Analogously, in a company law context, there's a distinction between the members altering the articles by special resolution, or the members removing the directors under their statutory power to do so, and the members directing the directors in relation to the day-to-day management of the company. The members can do the former, but not the latter. This distinction also exists in a private law context. The beneficiaries, if all of age, and sui juris, can invoke the rule in solemnis and voce and put an end to the trust, but they can't direct the trustees how to act in the administration of the trust. It's a pervading distinction which runs throughout chancery and company law, and to do what the appellant would ask would be to break away from that established regime, and would be to add a new jurisdiction to the court which hasn't formally existed. I think the point about labelling things as fiduciary has been dealt with to a substantial extent already. The one authority which hasn't been referred to orally but is in the bundle and does deal with this is Metoy Pension Trustees and Evans. It's in the first bundle of authorities, tab 22, MS 3891. It's a decision of Mr. Justice Warner. The relevant issue there was whether the power vested in the employer under a pension scheme to alter the payments due under the scheme was a fully fiduciary power. The relevant passage of Mr. Justice Warner's judgment for present purposes distinguishes between powers given without the donee being under any obligation to exercise or preserve it and fully fiduciary powers, and that's at MS 917. Starting at letter E. Three lines at E, as Mr. Walker pointed out, so to express the question is in a way to oversimplify it because there are different kinds of fiduciary power. Then skipping down to letter G, Mr. Walker suggested a more pertinent classification. Category 1 comprises any power given to a person to determine the destination of trust property without that person being under any obligation to exercise the power or to preserve it. Typical of powers in this category is a special power of appointment given to an individual where there is trust in default of appointment. In such a case, the donee of the power owes a duty to the beneficiaries under that trust not to misuse the power, but he owes no duty to the objects of the power. He may therefore release the power, but he may not enter into any transaction that would amount to a fraud on the power. A fraud on the power being a wrong committed against the beneficiaries under the trust in default of appointment. It seems to me to follow that where the donee of a power is the only person entitled under the trust, the power is not a fiduciary power at all. That's not relevant. And his category 2 comprises any power conferred on the trustees of the property or any other person as a trustee of the power itself. Calls a power in this category a fiduciary power in the full sense. Mr. Walker suggested as an example of such powers vested in powers vested in persons other than the trustees of property, the powers of managers of a unit trust. A power in this category cannot be released. The donee of it owes a duty to the objects of the power to consider, as and when may be appropriate, whether and if so, how he ought to exercise it.
What are we getting out of all this, Mr. Henderson?
What we're getting, again, is the point that a member of a charity isn't obliged to turn up at an AGM. Can't be a full fiduciary power. It's a power of the first category, suggested by Mr. Robert Walker and adopted by Mr. Justice Warner. It's also relevant that in the present case, as we've seen from the memorandum, not only may members be removed, they may resign. There's no obligation on somebody to remain a member if they don't want to. If Dr. Lehtimaki had resigned on day 2 of the hearing, or even on day 4 of the hearing before the Chancellor, under the Chancellor's judgment, there would have been nobody left who could have passed a Section 217 resolution, because there would be no members who could vote, because the Chancellor held that Sir Christopher and Miss Cooper couldn't vote.
Would there in that situation be a sufficient administrative impasse to justify a scheme?
Indeed, that might justify a scheme, but not a direction as to how to vote.
But if the court decides that the promotion of the objects is better achieved by having the assets within 2 separate charities, cannot the court decide to give ancillary directions, e.g., to a member to vote, where that is necessary to implement the decision?
I would respectfully suggest not, no. The scheme alters the constitution of the charity. The scheme could affect a division subject to the statutory constraints. In this context, or in the context of Milady's example, perhaps Section 217 wouldn't apply. The trust could be split. I mean, Varsani and Jasani was referred to earlier. That is a case where it was a trust case, not a company case, but there the trust fund was split by the court between the 2 warring factions by way of a scheme. And I would encourage you, if you do look at that case, to look not only at Sir Andrew Morritt's judgment, but also that of Lord Justice Chadwick, because Lord Justice Chadwick says, well, either it's a CPRE occasion, in which case we can change the purposes under the CPRE jurisdiction, or if we're not changing the purposes because the two warring factions are both objects of the existing trust, we can effect the split under the administrative scheme jurisdiction as being expedient in the interests of the charity. But that, again, is dealing with the framework. It's not ordering individuals as to how to exercise their discretions. Well, I'm very conscious of the time. I started 5 minutes late, but I've almost at the end of my full half hour. I would encourage you to look carefully at sections 197 and 198 of the Charities Act, the statutory constraints on what can be done in relation to corporate charities. They stop up any leaks which formerly might have existed and would have enabled charitable property to be applied for non-charitable purposes. The effect of having those statutory constraints is that there's no need to impose additional constraints by way of any sort of additional powers or any additional duties being imposed on the members. Unless there are any particular points I can help your lordships, the lady on at this
It
stage.
appears not. Thank you very much, Mr. Henderson. Mr. Pearce.
May it please your lordships, your ladyship, as the court knows, the Attorney-General seeks to make submissions in the public interest for the assistance of the court, and in this case, he invites the court to allow the appeal. The submissions he wants to make are on the following lines. First, that the powers of members of CIF are fiduciary powers. Second, that the Chancellor had power to order Dr. Lehtimaki as a fiduciary to vote in favour of the grant. And thirdly, that he was right to do so in the circumstances of this case. May I address those topics in turn? Strictly on the fiduciary duties issue, the only question is whether Dr. Lehtimaki is a fiduciary in respect of his power under Section 217 of the Companies Act. We say that there is no distinction between that power and the other powers of members of this company. As has already been pointed out, it's inevitable that the court's decision on this question will be taken to apply to other charitable CLGs with similar constitutions to CIF. The attorney understands that there is a desire in the sector for wide-ranging guidance and clarification, but he submits that this is not a suitable case for the court to undertake some kind of wide-ranging analysis of all different kinds of membership arrangements in the charity sector, and that it would be right for the court to focus its attention on the circumstances of this particular case. And he supports the reasoning of the Court of Appeal, leading to the conclusion that members of CIF are fiduciaries, and that they owe the specific fiduciary duty which the Court of Appeal identified in its judgment at paragraph 48. The attorney's positive case on this issue can be put very shortly, which is that there are 3 stages to determining whether one person stands in a fiduciary relationship to another. The first stage is to identify the characteristics of the relationship between the putative fiduciary and the putative beneficiary. The second is to determine whether those characteristics fall within the legal concept of a fiduciary relationship. And the third stage, if they do, is to determine what particular fiduciary obligations arise from that relationship. Looking at stage 1, the characteristics of the relationship, members of CIF have a range of powers in connection with the operation of the company, and there is no dispute whatsoever between the parties as to what they are. But the crucial circumstance is that the property of the company is solely applicable for charitable purposes, and that the members as such cannot benefit from it. in those circumstances, the correct conclusion to draw, it's submitted, is that a member of CIF undertakes his functions solely to advance the charitable purposes of the company, to the exclusion of any benefit for himself. Moving to stage 2, or question 2, which is whether those characteristics fall within the legal concept of a fiduciary relationship. The Court of Appeal took as a description of fiduciary relationships that of the Federal Court of Australia in the case of Grimaldi and Chameleon Mining, which is quoted in paragraph 38 of the judgment, and to which the court was taken earlier. And it submitted that members of CIF fall squarely within that definition, with a modification pointed out by my Lord Briggs yesterday, that when that definition and others contemplate a bipartite relationship, in this case, the obligations are owed to CIF's charitable purposes. And I would make the same submission if one took as one's definition of fiduciary relationship that in the case of Matthew.
I'm sorry, the obligations are owed to the purposes. Have I noted that correctly?
Well, my Lord, they are owed to the company. The company exists for charitable purposes. So it is acceptable in my submission to say that the members' obligations are owed to the purposes.
Is it better to say to serve the purposes rather
Yes.
than owed to? Owed to seems to me to encapsulate as your object something that must have some personality.
Yes. My Lord, I'm grateful I accept that. As to whether the counterparty, if you like, is the company or the purposes, it makes no practical difference in our submission, and it's simpler and clearer to think of the obligation as being owed or as being to serve the purposes. Moving on to stage 3, what particular fiduciary obligations arise from that relationship? The lower courts confine themselves to identifying only one, namely to exercise the member's powers in the way that he decides in good faith would be most likely to further the purposes of CIF, as set out in paragraph 48 of the judgment. And I submit that the lower courts were correct to identify this as a fiduciary relationship, as a fiduciary obligation arising from the relationship, and that it was unnecessary for them to go further with the purposes of this case. Insofar as there may be an appetite to go further, which the attorney does not encourage the court to do, the correct approach we submit is as set out in the F&C case, the decision of Mr. Justice Sales, which is in Bundle 1 at tab 13, particularly at pages 732 onwards, where the learned judge gives an illuminating analysis of the correct approach to determining what particular fiduciary obligations arise where a fiduciary relationship does not come within the paradigm categories of fiduciary relationship. That will be the process that one would go through if one were required to determine what additional obligations of a fiduciary nature arise as between a member of CIF and the company. Perhaps it would assist if we looked at that quickly. It's in Bundle 1, tab 13. The court was taken to this by my learned friend Lord Panning. The relevant passages start on page 732 using the MS numbering. What the learned judge is doing here is considering what fiduciary obligations are owed between the board members and the ManCom and the compensation committee members on the one hand of an LLP and the LLP itself on the other. And if I can take the court to paragraph 222, he distinguishes between paradigm situations and fiduciary duties arising in other contexts. And he says, in these contexts, it's just above letter E, it's necessary to examine with some care what is the precise content of the particular fiduciary obligation arising in the specific circumstances of the individual case. And moving on towards the bottom of the next paragraph, he says, the touchstone is to ask what obligations of fiduciary character may reasonably be expected to apply in the particular context where the contract between the parties would usually provide a major part of the contextual framework in which the question arises. And he goes on to expand on that in the following pages. So if we can move forward to the bottom of paragraph 225, for example, having referred to the speech of Lord Walker in the case of Hilton, he says it may also be the case that the overall contextual framework created by the contract simply means that it is not appropriate for the law to impose the whole range of possible fiduciary duties or fiduciary duties of particular kinds, particular types in the specific context. In other words, that it may be found that the parties could not reasonably expect that some particular duty of a fiduciary character should apply in the context of their particular relationship or in the context of their relationship with a person accepting appointment as a manager or board member. So, my lords, my lady, that is the approach that the court would adopt if it were to seek to move beyond identifying the single fiduciary obligation that the lower courts have adopted in this case. My lords, my lady, may I move on to address the arguments that have been advanced in the, by my learned friends in opposition to the conclusion that members of CIF are fiduciaries. And those arguments, in my submission, fall into three groups. There are arguments that that proposition is wrong in law. There are arguments that it is undesirable for members of CIF to be fiduciaries, and there are arguments that it's unnecessary for them to be fiduciaries. I can take those groups in turn. The first group of arguments is that the Court of Appeal was effectively wrong in law. And I shall run through the arguments as succinctly as I can. One argument that's advanced, and I refer, for example, to paragraph 143 of Dr. Lehtimaki's case, is that members of CIF have not assumed a responsibility to subordinate their interests to those of the charity. In my submission, that is simply not correct. The only possible explanation of somebody becoming a member of CIF, in my submission, is that they have agreed in that respect to subordinate their personal interests to those of the charity. A second argument, and I refer to paragraph 166 of Dr. Lehtimaki's case, is that members of CIF do not have direct control of CIF's property. And this is building on the analysis of the position of members of the LLP in the F&C case. The answer to that in my submission, that it's not necessary in order for a fiduciary relationship to arise for a person to have direct control of property. So, for example, a person who has a power to appoint trustees is undoubtedly a fiduciary in relation to that power, even though he doesn't have direct control of the trust property. A third argument is made, is that it would be inconsistent with the Charities Act for members of CIF to be fiduciaries. And this argument falls into two parts. Firstly, it's pointed out that section 220 of the Act imposes what might be termed a statutory fiduciary duty on members of a CIO, but that the Act doesn't impose a corresponding duty on members of charitable companies. My lords, my lady, I agree and adopt the submissions made by Lord Panic on that question. The answer to that point is that the Act deals with CIOs and charitable companies quite differently. In relation to CIOs, the Act has enacted a complete code for this completely novel form of incorporated body. And as part of that code, it spells out what one might call statutory fiduciary duties for members and directors or trustees. The Act has dealt quite differently with charitable companies. What has happened is that from 1960 to 2006, the legislation has gradually been expanded to include a series of specific provisions intended to protect assets of charitable companies against particular risks. And in that situation, it is not surprising in my submission that the Act has not enacted a specific definition of the obligations of the members of a charitable CLG, even in parallel to that which it enacts for CIOs. So the question is, can one infer from Parliament's failure to include in Part 10 of the Act a section corresponding to Section 220 in Part 11 of the Act, that Parliament understood that members of charitable companies stood in a different position to that of members of CIOs? In my submission, the answer is that one cannot draw that inference. And turning the point around, the recognition that members of charitable CLGs are under a duty corresponding to that of members of CIOs achieves, in my submission, a desirable consistency in the law. A second aspect...
So does the Section 220 duty in the CIO situation make members of CIOs fiduciaries?
My Lord, yes, it does. It is a statutory fiduciary duty. My Lord, the second part of the argument based on the Charities Act is that for members of CIF to be fiduciaries would be inconsistent with the structure of the Act as a whole. And the point is made that the Act says very little about members of charitable companies and that many of its regulatory provisions don't extend to them. So to give two examples, I don't invite your Lordships to turn these up, if I may just mention them. Section 210 of the Act gives the Charity Commission power to give written advice to charity trustees, and there is no corresponding power for the Charity Commission to give advice to members. And Section 191 of the Act gives power for the Charity Commission to relieve charity trustees from liability for breach of duty. But there is no corresponding power for the Charity Commission to do so in the case of members. And other examples can be given. But this difference in treatment, in my submission, has to be seen in the context of the structure of the legislation as a whole. The main method by which the 2011 Act regulates charities is by imposing obligations and conferring powers on charity trustees, which is a defined expression meaning the persons having the general control and management of the administration of a charity. In the case of a company, these are its directors and not its members. And so the focus of the Act is on the responsibilities of charity trustees, but it doesn't, in my submission, lead to the conclusion that members of CIF are not fiduciaries in relation to the limited functions that they have. My Lords, my Lady, moving on to the other arguments which have been put forward to suggest that the proposition that members of CIF are fiduciaries is wrong in law. Reliance is placed on the case of Bolton and Madden, the curious case about the two subscribers to a charity and their litigation over whether one was in breach of contract. I agree with the observations made by Lord Panic about that case. It is a curious case and it should not be influencing this court at this stage. I just make one further observation about it. In that case, the plaintiff was suing the defendant for damages equivalent to what he had had to pay to buy more shares in, or to subscribe further, to buy more votes, I think it was. He sued for the amount he'd had to pay to buy more votes in order to be able to elect his preferred candidate to be the recipient of the charity's bounty. In my submission, after he'd won, he was accountable to the charity for the proceeds of the judgment, because he was making a profit from his position in the charity by recovering those damages from his fellow member. My Lords, my Lady, that of course wasn't argued, but it goes to show in my submission that the analysis in that case of the position would not pass muster today. Another case relied on is the case of the Girls' Public Day School Trust against the Minister of Town and Country Planning. And again, I agree with my learned friend Lord Panic's submissions about that case. A further argument is based on Section 197 of the Charities Act, which we can find, and it would be helpful if the court turned it up, in Bundle 1, Tab 2, page 545 of the electronic numbering. If the court glances at that section, what it basically does is to say that if a company which is a charity changes its constitution so that it ceases to be a charity, there is imposed a form of asset lock on the assets that the company acquired while it was a charity, so they cannot be applied for non-charitable purposes. And the submission made, I think, in Tudor, perhaps elsewhere, is that this shows that the members of the company who would pass such a resolution were not fiduciaries. My Lords, my Lady, that section originates from a section in the 1960 Charities Act, which in turn was enacted to give effect to a recommendation made by the Radcliffe Committee, and one can find that in Bundle 3, Tab 49 at page 1645.
Sorry, could you give me that reference again, please?
Bundle 3, Tab 49, page 1645. And the relevant section of the report is paragraph 573. The writers of the report drew attention to the possibility that a company incorporated with charitable objects could change its objects. They recommended effectively that something be done to stop that. The recommendation that they made was not in fact the same as was adopted by the legislation. But in my submission, one cannot realistically interpret either the recommendation or the legislation as some sort of recognition that members of charitable companies were not fiduciaries in relation to their powers. It was simply a case of a law reform exercise plugging what was seen as a possible risk to the assets of charity. My Lord, moving on, if I may, my Lords, my Lady, moving on, if I may, to the second group of arguments. The argument is made that it's undesirable for members of SIF to be fiduciaries because of the obligations and implications of that state of affairs. A number of arguments are made in the proposition. First, it is submitted that this would deter involvement in charities. There are really two answers to that. Firstly, whether a person is a fiduciary or not is a question of law. It's not a question of policy. And secondly, insofar as policy is relevant, as the court has seen, the Charity Commission in its publication RS7 expresses the opinion that members of charitable companies are fiduciaries. A point was made this morning about whether that remains the Charity Commission's position, because it was some time ago that that publication was written. The attorney has inquired of the Charity Commission about that, and the Charity Commission remains of the views expressed in that publication, and it supports the conclusions of the Court of Appeal on this issue. A second argument is that the decisions of the lower courts create uncertainty. The answer to that in my submission is that the approach to the lower courts, which was effectively to allow the law to develop incrementally, is the correct approach. The learned judge had to decide this particular case, and he was entitled to do so without deciding other hypothetical cases, and the same was true of the Court of Appeal and is true of this court. My own friend Mr. Henderson has produced a number of questions which he says arise out of the question whether members of SIF are fiduciaries. Like him, I don't have time to go through them all, but I would like to address the court on one topic which is potentially the most significant of those he raises, which is the suggestion that if members of charitable CLGs, and SIF in particular, are fiduciaries, they have potentially unlimited liability. That is theoretically correct, but it has to be seen in context. And I have 6 short points to make about that. Firstly, the liability of members of a charitable CLG has to arise from the exercise of their functions. And members of a charitable CLG do not in general control its property or funds. So right at the start, the occasions which might potentially give rise to liability are restricted. Second, many of the functions of members that expose the assets of the charity to risk require the approval of the Charity Commission. See sections 198 and 201 and 202 of the Charities Act. So those provisions operate for the protection both of the charity and of the members, because the Charity Commission will be involved. Thirdly, a claim by a charity against a member for breach of fiduciary duty would in some circumstances be charity proceedings for which the prior sanction of the Charity Commission or the court would be required under section 115 of the Charities Act. Fourthly, if that were not the case, it would in practice be necessary for a charity that wanted to bring proceedings against a member to obtain bedo relief before doing so. And we have in the papers at Bundle 2, tab 34, an example in the case of Stanway and the Attorney General of how the court deals with an application for bedo directions against a fiduciary who is alleged to have caused loss to the charity. The court there considered not only the merits and value of the proposed claim, but also whether it was actually in the interests of charity to bring claims against volunteers. So the
You've got a memory stick number for that.
I'm sorry. It is Bundle 2, tab 34, MS page 1283.
Thank you.
That was my fourth point. The court can be expected to be robust in deciding what proceedings should be allowed if it's asked to give bedo directions. Fifthly, although, as I've already pointed out, there is no statutory power for the Charity Commission to relieve members of liabilities, the court and the Attorney General have an inherent power to release a fiduciary for a charity from liability in an appropriate case. The authority for that is to be found in the case of Rees Snowden, which is Bundle 5, tab 89, the relevant passages being at MS 2402 to 2403. So there is an inherent jurisdiction to make up for the lack of a statutory one. But sixthly, and finally, if a member exercises his powers in respect of a charitable company to cause loss to the charity, and the claim against him is not filtered out by one or more of the mechanisms that I have described, it is appropriate in my submission that the charity should have a remedy.
So would someone really need to take legal advice before becoming a member of a charity?
I would submit not, my lord, as a matter of common sense.
I mean, you've explained all this to us. Would all these alleged protections need to be explained to
Well, my lord,
the prospective member?
I was explaining this in the context of submissions being made that it is undesirable as a matter of policy for the court to acknowledge that members of CIF are fiduciaries. And I was explaining that insofar as the court is being pressed with an argument that it's undesirable to create a situation in which members are exposed potentially to unlimited liability, that is less of a concern than one might think at first sight. As to whether a member takes advice on anything, it's a matter for him, but it's a matter of common sense. One doesn't imagine that it happens, and in the light of what I've just said, that particular point should be one on which people's minds can be set at rest.
Is that part of their prerogative power to relieve?
Yes, yes.
Well, that's
as
assuming,
explained in the case of Snowden.
yeah. I mean, that's assuming the implications of your submissions are confined to charities.
Yes, indeed.
I mean, there may not be. I mean, if a critical consideration is the absence of a personal interest on the part of a member in the undertaking of the company, then it might not necessarily be confined to charities.
My lord, my submissions are only confined to charities.
Yeah. I know you're urging us not to look beyond this case, but it's if we're being asked to take a big step, it's difficult to avoid thinking about the implications.
Well, my lord, of course, but the answer to that is perhaps that it is not to be seen as a big step. The suggestion that members of charitable CLGs are fiduciaries has been part of the Charity Commission's written guidance for the last 20 years. And my lord, my lady, the final group of arguments which hasn't, I think, been pressed orally, is that it's unnecessary to impose fiduciary obligations on members of CIF because there are other protections, and reference has been made to the proper purposes doctrine and for the requirement for certain actions of members of charitable companies to be approved by the Charity Commission. It is correct that there are those protections in the general law, but in my submission that again is irrelevant, because whether a person is a fiduciary is a question of law. And that submission also runs counter to the way the legislation has dealt with CIOs. As I have mentioned, the legislation has enacted what I would describe as a statutory fiduciary duty for members of CIOs, but it has also copied across from the company's legislation relating to charities additional safeguards. So, for example, Section 198 of the Charities Act requires the Charity Commission to consent to regulated alterations to the constitution of a charitable company. This has been reproduced in the case of CIOs by Section 226, which requires alterations to the constitution of a CIO to have the Commission's consent. So when it was starting with as it were, a clean slate to create a regime for CIOs, Parliament thought it right to enact these two layers of protection, and that suggests in my submission that it's not an objection to members of CLGs being fiduciaries. There is also an additional level of protection for them and the charity in the legislation.
Mr. Pearce, I expect most people in this courtroom are members of the National Trust. We are all fiduciaries, are we?
My Lord, I simply don't make a submission on that. In the
Don't you need to help us with extent?
Well, my Lord, the Court of Appeal was clear that it was not dealing with mass membership charities such as the National Trust.
Well, the numbers can't be the test. I mean, where do you draw the line?
Well, my Lord, one thing is clear, which is that the National Trust is not a company limited by guarantee.
No doubt we could find...
It has a statutory basis, I think.
And, I mean, I don't know what duties members of the National Trust or powers they have, but one's main perception of having the little card is it gets you into their properties free, which on the face of it is a very nice and sensibly charged benefit compared to doing it as an ordinary member of the public.
Well, my Lord, I haven't dealt with the question of benefits to members because it hasn't been raised.
No, but I'm just reflecting that all I know about membership of the National Trust and from experience is I haven't read the Constitution. I've no idea what powers members have collectively or individually, save that they get free entry into National Trust property.
Yes.
Is that a satisfactory answer to my question, Mr. Pearce?
My Lord, what this court should do, in my respectful submission, is to confine itself to the decision of this case, which is whether members of SIF are fiduciaries. Neither of the lower courts thought it appropriate to go into the question of mass membership charities, to which completely different considerations would apply. And the court simply does not have the material to make any determination or quasi-determination about organisations of that kind.
There may be incidental benefits of membership which are not in themselves charitable.
My lady, there are potentially two concepts here. It is perfectly possible, of course, for anybody to enter into a contractual relationship with a charity under which he or she receives benefits in exchange for supporting it. So, for example, if one becomes, let us say, a friend of the Royal Opera House, one pays them money and in return one gets priority booking. That is a completely different arrangement from anything to do with having a constitutional role in the affairs of the charity. And it may well be, though this court cannot investigate the question on the material it has, that many arrangements which people loosely call membership arrangements are of that character. They are more in the nature of supporting and being a friend of the charity than actually being a constitutional part of its operation. I'm not speaking of any particular charity, but in general there is that distinction to be drawn.
It's a very long time since I belonged to the National Trust, but I remember being asked to vote on whether hunting should be permitted on National Trust land. So that's an example of how members, we don't need to talk about any specific charity, but it's an example of how members can actually, even in a mass membership organisation, play an active part in its management.
Yes. Well, my Lord, I can only repeat my submission that it's simply not appropriate or possible for this court to go into that kind of arrangement.
Well, we need to be able to base our approach on a principle.
Yes. My Lord,
ordinarily you base fiduciary relationships on the existence of a relationship involving trust.
yes.
Yeah, etymologically, that's
Yes.
what it means. And so you're usually looking at relationships of agency, trusteeship, and so forth, directorships, where one person is relying on another person to act on their behalf in a way which serves their best interests. And, well, that's the usual approach. But where that leads you in this instance may be the question.
Well, my Lord, in the case of SIF, you have a charity with very large assets and a very small membership. And it is entirely correct in my respectful submission to say that a person who becomes one of a very small group of members in that context assumes obligations which fall within the court's definition of a fiduciary relationship. Obviously, there are an infinite number of permutations, and one can well imagine circumstances in which that analysis might be questionable. But in this case, in my respectful submission, it's plainly correct. My Lord and my Lady, may I move on in view of the time to the other points on which the Attorney makes submissions, which is whether the Chancellor had power to order Dr. Lehtimaki as a fiduciary to vote in favour of the grant. I attempted to summarise some of the background of this issue in my written case at paragraphs 15 to 37, which is at pages 172 to 178 of the electronic bundle. I don't want to repeat what I said in those paragraphs, except to ask the court to correct a couple of typing mistakes in paragraph 37. Well, in paragraph 37, which is at page 177 of the electronic bundle, I said that a charitable trust is a trust for persons, not purposes. It is, of course, the other way round.
I did underline that with some question marks, to be honest.
I'm glad to have the opportunity to clarify that point. And in the next line, I intended to say that a direction by the court to the trustees of a charitable trust, not just of any trust, but a charitable trust, has the characteristics there mentioned. My Lords, my Lady, the Attorney General's submissions on this issue are premised on Dr. Lehtimaki being a fiduciary and subject to the control of the court as such. That is the significance, in this case, of the question of whether he's a fiduciary. The Attorney does not challenge the general principle that the court's inherent jurisdiction with respect to charities is part of its jurisdiction over trusts. He points out that that jurisdiction has been applied to charitable companies which hold assets beneficially by treating them as being analogous to trusts. That was established by the Liverpool and District Hospital case to which the court was taken this morning. And the Attorney accepts that the court will not interfere with the exercise of a fiduciary discretion except in limited circumstances, which I'd like to call the non-intervention principle, and that this principle applies both to charitable trusts and to private trusts. The court was taken to Lewin, paragraph 29, 336, MS page 1625, for that proposition yesterday. The leading statement of what I have summarised as one of the leading statements of what I've summarised as the non-intervention principle is the case of beloved Wilkes, which was itself a charity case, which is in bundle 2 at tab 28. And the court will recall at page, the electronic reference is page 1205. The court will recall, looking at page 1208 of the electronic pagination, that Lord Truro's statement of principle concludes as follows: the duty of supervision on the part of the court will thus be confined to the question of the honesty, integrity and fairness with which the deliberation has been conducted, will not be extended to the accuracy of the conclusion reached except in particular cases. And in my submission, the question posed by this case is whether the circumstances of this case constitute or fall within the exception to the principle as stated by Lord Truro. And the Attorney's submission is that the decision of the Chancellor to direct Dr. Lehtimaki how to vote can be reconciled with authority by saying that the particular cases referred to by Lord Truro in Beloved Wilkes include, in the case of a charity, where it is expedient, alternatively necessary, for the court to intervene in its affairs. I put expediency and necessity as alternatives in that proposition. The submission in the Attorney's written case is that the court can depart from the non-intervention principle when it's expedient to do so in the interests of charity. And the test of expediency has the attraction of being that applied by the court in Re Lang and used in several contexts to confer powers on the Charity Commission. But that submission actually goes further than is needed to deal with this case, as my Lord Kitchen pointed out yesterday, because the language of the Chancellor in this case shows that he considered it necessary to intervene. May I refer the court, without asking you to turn it up, to paragraph 155 of the Chancellor's judgment, which is at page 297 of the electronic bundle, where he said, in the circumstances of this case, the interests of CIF and of charity demand that the grant is approved. So the Chancellor's decision effectively was that intervention was not just expedient, but necessary. And there is a
demand that grant be approved, or demand that I order the Dr. Lehtimaki to vote in that way. What's the context?
We should look at the judgment, my Lord.
I mean, you quoted a bit which said demand that the grant be approved.
Yes.
If he's also said demand that I order this against Dr. Lehtimaki, then that's it.
Next sentence.
I think, yes, I think the answer to my Lord's question may lie in the last sentence of paragraph 155.
Thank you.
My Lord, I'm most grateful. The last sentence to which my Lord Kitchen has referred is the only remaining voting member of CIF must be directed to approve it, otherwise the essential interests of charity, which the court is there to protect, will be put at risk.
Very well, thank you.
I think I read the Chancellor as saying that it's not merely that this is a beneficial grant in the sense that it serves the interests of the charity, but he's saying it would positively be a disservice to the interests of the charity if the grant were not to go ahead.
Yes. My Lord, my point is that in considering on what basis he should give a direction to Dr. Lehtimaki, he effectively decides not only that it's expedient, but also that it's necessary that he should do so. So, my Lords, my Lady, I'd like to advance three propositions, which are as follows. The courts have not exhaustively defined the exceptions to the non-intervention principle. Second, the courts should recognise that an exception to the non-intervention principle may arise if the court considers it expedient, alternatively necessary, to intervene in the affairs of a charity. And thirdly, if the court does decide to intervene, that its powers extend to giving a specific direction to it.
I'm so sorry, I couldn't hear the last one.
I'm sorry?
I didn't hear the last point.
The third proposition is that if the court decides to intervene, its powers extend to giving a specific direction to a fiduciary.
Thank you.
Taking first point one, which is that the courts have not exhaustively defined the exceptions to the non-intervention principle. The foundation for this submission is the statement of principle by Lord Truro in Beloved Wilkes, which concludes with reference to particular cases. And the leading authority on how to interpret that qualification in my submission is now the decision of this court in Pitt and Holt, which is in Bundle 1 at tab 25. Maybe go straight to page 1031. In paragraph 71 onwards of his speech, Lord Walker is addressing the question whether a breach of duty on the part of the trustee is necessary to engage the rule in Hastings-Bass. One sees that at letter A on page 1032. Going on to paragraph 72, Mr. Ham contended that the supposed need for establishing a breach of duty for Hastings-Bass was a novel requirement introduced by Mr. Justice Lightman. And then at paragraph 73, Lord Walker says, in my view, Mr. Justice Lightman was right to hold that for the rule to apply, the inadequate deliberation on the part of the trustees must be sufficiently serious to amount to breach of fiduciary duty. Breach of duty is essential in the full sense of the word because it is only a breach of duty on the part of the trustees that entitles the court to intervene. Apart from the special case of powers of maintenance of minor beneficiaries, where the court was in the past more interventionist, see paragraph 64 above. It's not enough to show that the trustees' deliberations have fallen short of the highest possible standards, or that the court would, on a throne of discretion by the trustees, have acted in a different way. Apart from exceptional circumstances, such as an impasse reached by honest and reasonable trustees, only breach of fiduciary duty justifies judicial intervention. So in that paragraph, we have two qualifications referred to. One is the exercise of powers of maintenance of minor beneficiaries, where Lord Walker refers back to paragraph 64, and the other is exceptional circumstances, of which he gives a non-exhaustive example of an impasse. If we look back at paragraph 64, Lord Walker there mentions two cases dealing with the maintenance of minor beneficiaries. And he says at the end of paragraph 64, the old cases as to the maintenance of children are rather exceptional, especially where the position was complicated by the child in question being a ward of court. If we can return then to paragraph 73, he goes on to discuss the case of Carr and British Leyland. And the significance of this case, the court has already been taken to this passage, is that this was a case where the Court of Appeal held that the trustees were not in breach of duty, were not at fault. That appears 4 lines up from the bottom of page 1032. But nevertheless, the court intervened to set aside a decision that they had made. And Lord Walker explains this at paragraph 75 as being, if I can look at the last sentence, a case where the corporate trustee had to exercise a judgment on an issue of fact. This is an issue on which the court would be much more likely to intervene if the trustee had failed to grasp the real fact. It's an intermediate situation, which is arguably closer to a mistaken judgment on an issue of fact than the defective exercise of a discretion. And then carrying on through this part of the judgment, Lord Walker sets out at paragraph 77 various other aspects of Mr. Ham's argument. And the last of them is what he describes as special meaning irrelevant. One sees that after figure 4 in paragraph 77. And he comes to that, paragraph 88 of the judgment, where he summarises the submission, says it's, this is at the top of the next page, truly the last-ditch argument. He refers to beloved Wilkes, and he continues, the trustee's duty does not extend to being right, the accuracy of the conclusion arrived at on every occasion. The particular cases that Lord Truro had in mind may have included cases concerned with the maintenance of minor beneficiaries, and we've seen that he dealt with that at paragraph 64. They may also have included cases such as Carr, in which the trustees have made a particular factual judgment rather than exercise a wide discretion. We saw that at 74 to 75. So what we have here is the giving of various examples of what, in Lord Walker's view, would constitute particular cases within the ambit of what Lord Truro is referring to. And it's important to appreciate that one cannot deduce the particular cases that Lord Walker mentions from anything in Lord Truro's judgment itself. They are examples taken from the case law of where the court has departed from the non-intervention principle to substitute its own view for those of trustees who were found not to be in breach of duty. Lord Walker does not suggest that they are the only possible examples. They are suggestions, if you like, by Lord Walker of past decisions of the courts that might fall within the description of particular cases in Lord Truro's statement of principle. So Pitt and Holt, in my submission, is a very recent decision of this court, recognising that in the field of trusts, the non-intervention principle admits of exceptions which the courts have not exhaustively defined. And in my submission, the court is wise not to state the non-intervention principle in unqualified terms. To admit that the principle can allow exceptions does not undermine the principle itself. There are many good reasons for the principle. For example, that the court cannot undertake a duty of continuing supervision. The court may well be less well placed than the trustee to make a judgment. The set law chose the trustees, not the court. All of those are reasons that are given for the non-intervention principle. But where in any particular case the reasons for that principle do not apply, the court should be free to depart from it. In my submission, taking the case of beloved Wilkes and Pitt and Holt together, the court has been careful to reserve to itself a residual power not to apply the principle. And the case of Letterstead is, in my submission, a reminder that the court's basic function is to safeguard the interests of beneficiaries or of charity. Usually that will be best achieved by adhering to the non-intervention principle, but exceptionally it may well be best achieved by taking a different course. My Lords, before I move on, may I briefly mention the case of Hampton and Earl of Buckinghamshire. In view of the time, I don't intend to take the court back to that case, but the interest of it, in my submission, lies in the comparison between the approach of the judge at first instance and of the Court of Appeal. If the court goes back to that case when it's considering its decision, and it's in Bundle 1 at tab 17, the court will see that the judge at first instance took a very conventional view. He applied the non-intervention principle and said that I simply cannot interfere with the judgment of the tenant for life as to whether it's appropriate to mortgage the settled land in this particular way. When one gets to the Court of Appeal, as my learned friend Mr. Morpus pointed out yesterday, Lord Justice Lindley characterises the question as whether the proposed mortgage would be a breach of trust. But it's not clear from the language that he uses when he analyses the effect of the proposed mortgage that he is saying it's a breach of trust. What he says, to paraphrase...
Could I have a page?
I'm sorry?
Could I have a page?
My lord, I'm so sorry.
Well, come back to it by all means if I'm interrupting your flow.
No, I would like to be able to give you the page, my lord. It's Bundle 1, tab 17, and the electronic page reference is 791.
Thank you very much.
Again, I'm trying to save time by not asking the court to reread it, but what Lord Justice Lindley says is, assuming the tenant for life is acting bona fide and with a view to preserving the estate for those intended by the settlor to enjoy them, still an honest trustee may fail to see this acting unjustly towards those whose interests he is bound to consider, and if he is so acting and the court can see it, the duty of the court is to interfere. That decision is, in my submission, capable of being classified as another particular case under the framework of Lord Truro's judgment in Beloved Wilkes. It would not have been out of place as a third example given by Lord Walker in Pitt and Holt. So in my submission, the non-intervention principle admits of exceptions that the courts have not exhaustively defined. The second proposition I wish to advance is that the court should recognise that an exception to the non-intervention principle may arise if the court considers it expedient, alternatively necessary, to intervene in the affairs of a charity. And in support of that proposition, I draw attention to four special characteristics of charities. First, the courts are exercising a jurisdiction which is derived from the Crown as parens patriae, and which is there to protect the public interest. The jurisdiction is part of the court's jurisdiction in respect of trusts, but it has a different origin to the court's jurisdiction in respect of private trusts. Second, a charity is essentially a purpose. In a sense, the court is not just supervising the actions of a trustee, but it's also representing the public interest. The case is analogous to one where all the beneficiaries of a private trust are sua juris before the court. In that situation, the beneficiaries cannot compel the trustee to do anything while the trust continues, but their unanimous agreement relieves the conscience of the trustee, and that is similar to the position where the court is concerned with the affairs of the charity. Thirdly, the courts recognise that the law shows favour to charities. The favour shown by the law to charities is referred to in two of the greatest speeches in the House of Lords in charity cases. May I just briefly take the court to them? First in time is the judgment of Lord Macnaghten in Pencil's case, which is in Bundle 4, tab 23, MS page 970. I'm sorry. Pencil's case, the electronic page reference is 2116, Bundle 4, tab 72, at page 2116.
Repeat that, please. 4.
Bundle 4,
Yeah.
tab 72,
72.
page 2116.
Thank you.
Lord Macnaghten says that according to the law of England, a technical mean is attached to the word charity and to that word charitable, and to the word charitable in such expressions as charitable uses, charitable trusts. The Court of Chancery has always regarded with particular favour those trusts of a public nature which, according to the doctrines of the court, derive from the piety of early times, etc. So I draw attention to the phrase particular favour. Lord McNaughton is not talking about the non-intervention principle. He's talking about other aspects of the law. But the proposition that the courts look on charities with particular favour is, in my submission, a general proposition. Similarly, in Bundle 1, tab 23, MS page 970, in the National Anti-Vivisection case, another leading authority in the law of charity, Lord Simmons, at page 970, says this: nowhere perhaps did the favour shown by the law to charities exhibit itself more clearly than the development of the doctrine of general charitable intention. So again, in this leading case, Lord Simmons recognises that the law shows favour to charities. And fourthly, the court already has a broader jurisdiction than in private trusts, in the case of charities, namely to make schemes. In my submission, the combined force of these points is that the court should be more ready to depart from non-intervention principle in the case of a charity than in the case of a private trust. So my submission effectively is that the decision of the Chancellor to direct Dr. Lehtimaki how to vote can be reconciled with authority by saying that the particular cases referred to by Lord Truro in Beloved Wilkes include, in the case of a charity, it's expedient, alternatively necessary, for the court to intervene in its affairs. And my third proposition, or my third point, is that if the court decides to intervene, its powers do extend to giving specific directions to a fiduciary. Can I deal with it to get out of the way? A point made based on section 20 of the Charities Act, which I don't invite the court to turn up. Section 20 of the Charities Act says that the Charity Commission may not intervene in the administration of the charity. I'm sorry, the words are, the Charity Commission may not be directly involved in the administration of a charity. The submission has been made to the court that that replicates the position of the court. In my submission, that is not a necessary inference from section 20. It is not the case that the powers of the Charity Commission are intended to duplicate those of the court. It is not the case in my submission that there is a prohibition on the court becoming directly involved in the administration of a charity. It may well choose not to do so, but there is no statutory or analogous prohibition on it doing so. My lords, as to the proposition that the powers of the court do extend to giving specific directions to a fiduciary, in view of the time, I would like to deal with this in the same economical way that my then friend Mr. Morpus dealt with it, which was by taking the court to Pitt and Holt, specifically at paragraph 63, page 1029. In that's MS page 1029, paragraph 63 in Pitt and Holt. What Lord Walker does is to refer to the speech of Lord Wilberforce in Re Barden's Trust Deeds, where the court, where Lord Wilberforce stated that if the court is called upon to execute a trust power, it will do so in the manner best calculated to give effect to the settlor's or testator's intentions, and it may do so in various ways, including, finally, should the proper basis of distribution appear, by itself directing the trustees to distribute. So in Macfarlane Dalton, the House of Lords recognised that where the court is executing a trust power, it can give directions to trustees which include, in appropriate circumstances, a specific mode of application of the trust property. And I would invite the court to look at the earlier pages of Lord Wilberforce's speech, where he gives a number of examples taken over the centuries where the courts have directed the execution of trust powers by ordering a specific distribution of trust property.
Was that in the context of breach of trust?
My Lord, no, it's in the context of the court having the power becoming unexercisable for some reason or other. Where the court has to execute the trust, the proposition is it can do so in a variety of ways, including giving specific directions. Lord Walker makes the point that in Metoy's case, which the court was taken to by learned friend Mr. Henderson, Mr. Justice Warner applies McPhail and Dalton, and what Mr. Justice Warner holds in Metoy is that the court can give a particular direction as to how a fiduciary power should be exercised in circumstances where there was nobody available to execute it, to exercise it, I should have said. What one gets from those three cases, McPhail and Dalton, or Barden as it's called, Metoy and Lord Walker's approval of those two cases in paragraph 63 of Pitt and Holt, is that the court can execute a fiduciary discretion by directing what is to be done. My Lord, against that, I should take the court back to paragraph 74 of Pitt and Holt, where Lord Walker cites with approval the decision of Lord Justice Fox in Carr, where, having decided in Carr that it was appropriate for the court to intervene, Lord Justice Fox went on to say that the court was not entitled to direct the fiduciary what to do. It could set aside the decision, but the choice of action was for the trustees. My Lord, there might well be thought to be some inconsistency between Lord Walker's approval of what Lord Wilberforce had said in paragraph 63 and his approval of Lord Justice Fox's statement, paragraph 74. I draw that to the court's attention.
Well, isn't the reconciliation possibly that in paragraph 63 he's using Lord Wilberforce's citation as what he calls a reminder that where trustees have been in breach of duty by exercising a discretion with elaborate deliberation, setting aside may not be the only course open to the court. So he's treating it as at any rate, in a breach of duty context, even if Lord Wilberforce may have gone rather wider.
Yes, my Lord, that may be the reconciliation, but the point which is relevant for present purposes of my submission is that in appropriate circumstances, and of course the question is what are appropriate circumstances, the court can execute a fiduciary power by directing the fiduciary what to do. And in my submission, that approach is capable of being applied to the present case if the court decides to intervene in the exercise of Dr. Lehtimaki's discretion. By analogy with McPhail and Dalton, the court has power to direct how the power will be exercised. The point made by my friend Mr. Morpeth was that the exercise of the power by Dr. Lehtimaki is not impossible. But if the court decides to intervene before the exercise of a power by the fiduciary, giving a direction to the fiduciary is the only practicable means of doing so. The cases show in my submission that the modes of intervention available to the court include giving a direction in an appropriate case. My Lord, my Lords, my Lady, may I finally move on to deal with the disposition of the present case?
You'll have to do so very, very briefly.
I will do so in no more than 2 or 3 minutes. If the court accepts that in the case of a charity, the court can depart from the non-intervention non-intervention principle where it's expedient or necessary to do so, and can give a specific direction to the holder of fiduciary power, the court was, in my submission, correct to do so in the circumstances of the present case. As the Chancellor said, the circumstances of the case were truly exceptional and were unlikely to recur. The relevant circumstances included these: that the Chancellor had accepted a surrender of the trustee's discretion as to whether to make the grant. The trustees therefore must be taken to have placed before the court all relevant information to enable the court to make the decision, and the Chancellor must have been satisfied that that had been done. The decision that Dr. Lehtimaki had to make was, in my submission, the same as that which the Chancellor had made. And the basis on which the judge decided to give the direction was twofold. Firstly, he had decided what he considered was the correct course for the trustees to take on the question which they had surrendered to him. He had read the witness statement of Dr. Lehtimaki setting out his position. He was faced with the possibility that his decision might be overridden by Dr. Lehtimaki. He did not suggest that no one could reasonably differ from his conclusion, but he concluded that notwithstanding the possibility for reasonable disagreement, it was in the best interest of charity that the grant should be made, and in those circumstances he gave his direction to Dr. Lehtimaki. My submission is that he was entitled to form that view in the particular circumstances of this very unusual case, and that this court should uphold his decision to do so. My lords, unless I can assist further, those are my submissions.
Just a very quick question. If there was no scheme, why no scheme in this case, which could have implemented the arrangements?
My lady, in my submission, the order that the court made was not a scheme. Mm-hmm. But my analysis is that the court was effectively acting by way of identifying a permissible exception to the non-intervention principle. So it was acting in accordance with the principles on which the court controls the exercise of fiduciaries. It wasn't exercising a scheme jurisdiction. It didn't have to, because it was controlling the exercise of a fiduciary's discretion.
Thank you very much.
Thank you, Mr. Pearce. Lord Panic.
My friend's amicus complained to the court on behalf of Dr. Lehtimaki that the Chancellor did not have all the necessary information, and that was because Dr. Lehtimaki was joined at the last moment. Can I just remind the court of factors relevant to this complaint, which have not been mentioned so far on this appeal, and they appear in the Chancellor's judgment, MS 264, paragraph 35. It's tab 4 of the appendix, MS 264, paragraph 35. And what paragraph 35 refers to is the first witness statement of Dr. Lehtimaki. My friend showed the court the second witness statement. And paragraph 35 points out in the second sentence that Dr. Lehtimaki had provided a first witness statement on the 11th of July 2016. That was 10 months before the hearing in front of the Chancellor. And the Chancellor summarises what Dr. Lehtimaki said, and the court will read it. And over the page, at the top of 265, one of the things that Dr. Lehtimaki said was that he was, quote, neutral as to whether or not the grant should be approved. At paragraph 36, the Chancellor noted that about a month before the hearing, Dr. Lehtimaki's solicitors wrote to the court with a letter from Dr. Lehtimaki. And I won't read it all out, but about 6 lines down, 8 lines down, the court will see that one of the things Dr. Lehtimaki said was that he had declined the invitation to become a defendant to these proceedings, and he gave his reason. And the Chancellor at paragraph 37 records that Dr. Lehtimaki had declined to become a party to the proceedings. So it is simply incorrect to suggest that Dr. Lehtimaki first appeared on the scene of these proceedings on day 3 when the Chancellor joined. He'd issued a witness statement months earlier and he declined to be a party. He had ample opportunity to participate in these proceedings, to put before the Chancellor such material as he wished. In relation to the law, we for our part see the force of the submission in favour of a general principle of non-intervention in trust law and charity law. The question for the court is whether this is an exceptional case. See beloved Wilkes, MS 1208. And what is plain from the Chancellor's judgment is that he regarded this as such a case. That is, a case where the court had been asked by the charity, it had been asked by the Commission to resolve a particular problem that was causing enormous damage to the efficiency, the effectiveness of this valuable charity. And he had answered it in the affirmative, that the grant is in the interest of the charity, and he, the Chancellor, had regarded it as necessary to direct Dr. Lehtimaki to vote accordingly. There is no appeal against the judgments of the Chancellor that A, this grant is in the interests of the charity, and that B, on the facts of this case, it was necessary to issue a direction to Dr. Lehtimaki. The appeal is on the point of law as to whether or not the Chancellor has a power to direct a member who has not himself surrendered his discretion. So the question for the court in my submission is whether the Chancellor may, in such exceptional circumstances, give a direction to the member in a case where the Chancellor has been asked to determine whether the grant is in the interests of the charity. The Chancellor has determined that question, and we say the Chancellor must have an implicit power in those circumstances, if he thinks it necessary to do so, to direct a person who is, in the words of the Court of Appeal, paragraph 45, part of the administration of the charity, and in the words of section 1 of the Charities Act 2011, part of the institution. A person who has a duty only to act in the best interests of the charity. Mr. Morpus disputed that there's a fiduciary duty, but he accepted that the section 217 function may only be exercised by the member in the interests of the charity. And we say that the Chancellor was entitled to conclude that once the court has ruled on the question that's been put before it by the Commission and by the charity, it is not open to the member to gainsay the conclusion that the court has reached, particularly when the person concerned was a party to the proceedings. My friend said this was not in the grounds of appeal. With respect, that's not right. If the court would look at MS 27, the court will see paragraph 12D, subparagraph 12D, of our grounds of appeal to this court, page MS 27. It's at the bottom of MS 27, just before 13, we refer to what the Court of Appeal said, and then we say, once the Chancellor has decided that the grant is in the best interests of charity, and that conclusion has not been the subject of an appeal, that issue is resolved in law. Dr. Lehtimaki cannot properly demur from this conclusion and thereby frustrate the decision of the court and the unchallenged interests of charity.
If that's right, Lord Panic, why isn't a threatened demurral a breach of duty?
Breach of duty by the member.
Yes.
Well, it could be put that way, and that's no doubt another reason why the Chancellor's decision to give a direction is at least justified, because
Everyone accepts that there's a breach of duty gateway to the court's intervention.
I accept your Lordship's point. If Dr. Lehtimaki were to defy the court having determined that the grant is in the interests of charity, then yes, I take your Lordship's point, but it takes us back to the same issue as to whether or not the decision of the court binds Dr. Lehtimaki. But I respectfully agree with your Lordship. A suggestion was made by Mr. Morpus and Mr. Crowe that the question for the court, that is the Chancellor, was a different one from the question for the member under section 217, and I do not accept that. First of all, as my friend Mr. Morpus developed the sort of arguments that Dr. Lehtimaki may wish to take into account, it became apparent that these were factors that could, and in some cases were put before the Chancellor as to why the grant is not in the best interests of charity. Secondly, there was a suggestion that the interests of CIF may differ from the interests of charity generally. But that's, with respect, a very weak point when CIF is a grant-making charity with the widest possible charitable interests. The interests of CIF merge, so far as it matters, with the interests of charity generally. Thirdly, and my Lady Arden put this point to my friend Mr. Morpus, the Chancellor was not just approving the grant, he was approving it as part of a broader agreement to resolve a dispute. See paragraph 128, which is on MS 290. And the Chancellor there dealt with the submission which Mr. Crowe made to the Chancellor, which he repeated to the court, that things have moved on because the agreement resolved the problems in CIF. And fourthly, Mr. Crowe had a further point. He said relevant factors may now have changed. But your Lordships, in my submission, your Ladyship, are addressing the legality of the direction made by the Chancellor at that time. And if there was fresh evidence between 2015 and 2017, it could and should have been put before the Chancellor. And in any event, the Chancellor expressly stated at paragraph 1281, paragraph 128, subparagraph 1, it's MS 290, that he was not persuaded that anything of significance had changed since the agreement in April 2015. Again, no appeal from that judgment. So I say that this provides the simplest basis for resolving this appeal. The Chancellor was asked to decide a specific question asked by the Charity Commission. He decided it, and the member, given his role, his responsibilities, cannot gainsay the court's answers as to what is in the best interests of this charity in all the circumstances of this case. The Chancellor was entitled to regard this as an exceptional case and to do so in particular because whatever the boundaries of the special jurisdiction as to charity are, and that's a very difficult question, they must be sufficiently broad to allow the Chancellor to resolve this case, which he regarded as so exceptional. Mr. Morpeth said the Charities Act Section 20 prevents the Commission being directly involved in the administration of a charity. Friend Mr. Pearce has dealt with that. I just emphasise 2 points. We say the 2011 Act does not purport to regulate the inherent jurisdiction of the court. It would be surprising if it did. And in any event, what the court was doing in this case, that is approving an important transaction as part of an agreement to resolve the serious problems that were faced by this charity, when asked to do so, is not for the court to become directly involved in the administration of a charity. There's an important difference between what the Chancellor was doing here and the direct involvement in the administration of the charity. Our appeal is not dependent upon the finding of a fiduciary relationship. It suffices for our purposes that, as Mr. Morpeth accepted, the Section 217 function may only lawfully be performed by the member in the interests of the charity. My friend expressly accepted that. He did not submit that it is open to his client to vote according to any other consideration. And it's that consideration in my submission which the court has already determined. And therefore, I do not suggest to your lordships, your ladyship, that it is necessary for the court to pronounce on the important question, difficult question, of whether there is a fiduciary relationship. If it is determinative, if the court takes the view that the answer to this appeal depends upon that issue, then I respectfully agree with Mr. Pearce that the member does owe a fiduciary duty in respect of his Section 217 functions. My Lord Wilson asked my friend whether a member would need then to take legal advice before accepting that status, before acting on that status. I respectfully point out to my Lord that Parliament has imposed a fiduciary duty on members of charitable incorporated organisations, CIOs, by Section 220 of the 2011 Act, and Parliament cannot therefore have been over-concerned that this would deter people from becoming members. And I made the point in opening, my friend Mr. Pearce repeated it, that the Charity Commission in their guidance don't seem too concerned about the practical implications. And the reason for that may be, in answer to my Lord's further question, important question, are members of the National Trust fiduciaries? My answer to that question is it all depends on the function that they are performing. Because as I indicated in opening, it is not my submission that a member is a fiduciary for all purposes. And my lady put that point to me, and that was the reasoning of Mr. Justice Sales in the F&C case. What one has to do is look at the specific function that is being performed and ask the question whether it creates a fiduciary duty or not. And I would respectfully agree with my Lord the President that the answer cannot depend on the number of members. That's not my submission. It depends on the function. So without seeking to avoid my Lord's question, it's a very important question if the court goes along this route, if the court thinks that being a fiduciary or not is crucial to the answer in this case. A member may be a fiduciary dependent on the function that he or she is performing. And the function that this member is being asked or would be asked to perform under section 217 is, for the reasons we've given, a fiduciary responsibility. But other functions of a member, other activities of a member, no doubt would not be fiduciary in nature. That leaves section 217. If we are otherwise correct, we maintain the submission that section 217 does not remove the power of the Chancellor to give a direction in the exceptional circumstances of this case. And that is because this case arises in a context where the decision to approve the grant has been taken not by the directors, it's been taken by the court. And the mischief against which 217 provides protection is the directors deciding in their own interests that they are going to receive, or one or more of them is going to receive a benefit. And there is no reason to think that where the court has determined that a particular grant is in the interests of the charity, that Parliament intended by section 217 to deprive the court of the powers it would otherwise enjoy to give a direction to the member as to how he or she should perform his section 217 functions. I say a much more explicit statutory provision would be required before one would reach the conclusion that Parliament had intended to remove or confine the powers which the court otherwise enjoyed. Any other points were raised. I'm happy to seek to deal with any of them if I've missed any of importance, but that's the substance of our reply to what we regard as the essential, basic, important interests in this appeal. Unless I can assist further, that's what I wanted to say by way of reply.
Thank you very much indeed, Lord Pennick. Well, the court is grateful to all counsel for very helpful submissions in this interesting case. And we're also grateful to those sitting behind them who no doubt have also put in a great deal of work. We will now take time to consider our decision.